Good morning, everybody. My name is Ursula Kilkelly, and it's my privilege to be the Dean of the Law School here at University College Cork. You're all very welcome to this very important event this morning. I'm going to do the formal bit this morning, really, in open proceedings, and I'm going to hand over to Tanya, the Chief Executive of the Children's Rights Alliance, who's going to introduce our guest of honour, Judge Albie Sachs, who's travelled to be with us for this important event. But I know you have a very impressive lineup of speakers and chairs to hear and to discuss these very important issues with you this morning, and you'll have an excellent day. The law school prides itself on not only its excellence in scholarship, but also its connection to issues of importance in law, in the implementation of law, and in the social application of law. And this is, I think, one of those areas where the law school over the last 10 years in particular, I suppose, has built up a really substantial body of work and has, I think, grown also in size in terms of the number of my colleagues and students at both graduate and PhD level who have been engaged and become engaged on children's rights issues. So I'm particularly pleased as the Dean to open an event such as this. And for many of us who are involved in children's rights, there are really so many issues that you could hold a day's conference on. So many key concerns and matters of importance to children and their families. And often those less visible, less high profile issues really don't get the attention that they deserve. And the question of the rights of children affected by parental and indeed family imprisonment is, I think, one of those issues. And it has struck chord with me on two occasions over the last 4 or 5 years. The first was when the law school was undertaking its education programme in Cork Prison, where a number of us went in and spent time with the prisoners as part of a formal education programme on the law. And I was there to talk about young offenders. They had their own views on the youth justice system, which were really important. But we also straight in, and other colleagues went in to talk about family law issues. And it was really so obvious that apart from their own imprisonment and the impact of that on them, it bore really heavily on the men that we spoke to, that they had left behind them in the community, their children, that often they were struggling with matters of custody and access, what the future held for their relationships with their children. And it was a really acute concern that I took away from that meeting. The other encounter that I had with this issue was a number of years ago, in 2010, I did a large piece of work for the Council of Europe on children's experiences of justice. And predominantly we reached out to children in an online international survey where we heard from children about their experiences and their views on how the justice system treated them. But one and many of the national partners in the project undertook consultation with children, and one of those sessions that I attended was in London with a small organisation there to support the families of those imprisoned. And we had the privilege of spending a couple of hours with some preteens whose lives had been marked very heavily by not just family, sibling and parental imprisonment, but actually their family's whole relationship with the justice system. And in particular, their experiences about being in and out of prison, how little empathy there was, they felt, in how the system treated them as complete innocent bystanders in the process, even down to the physical searching and stamping of their hands, which they felt was done without any real regard for the fact that they were not adults. And that was, I think, one of the things that they really felt. They also talked, of course, about going in to visit their brothers and their sisters and their parents and their uncles and aunts in prison, and talked about how they were suddenly forced into cross-the-table conversations with people who they'd really never sat across the table from at all, and how inappropriate this was for the sustaining of their relationship with their family members. And I think also very remarkably then the broader impact of the justice system on those children. The violations of their houses, their homes as they saw it, their bedrooms in some cases by the police, undertaking night raids and taking parents and family members into custody. And again, how little impact or little consideration was given to the impact of that, really life-changing impact that had on them. So with those two very anecdotal experiences in mind, I'm really delighted that Fiona and Aisling have not just had the idea, of course, to bring this issue to the fore, but to put together with a whole range of other bodies, the Irish Research Council, our Centre for Criminal Justice and Human Rights here and the Law School, a really excellent programme which I know will stimulate you, I think will hopefully allow you to network, also to bring together your own knowledge and experience so that a more concrete visibility can be brought to this issue at a national but also at an international level. I met colleagues in Brussels yesterday at an international juvenile justice event from penal reform. I know this is an issue of international concern and that other countries have made much more progress than us, so I know you will benefit greatly from hearing from those other external international perspectives too. So congratulations to Dr. Parks and Dr. Donson. Thank you to all the law school staff who support these events, and I hope you have a fantastic day. Very regrettably, I have multiple other things in my diary, so I'll be hoping to dip in and out, but I know that certainly you'll have an excellent event, and I wish you all the best with it. Thank you. I should, of course, have introduced Tanya Ward from the Children's Rights Alliance. Tanya, we're delighted that you're here, and obviously very important to have Ireland's leading NGO on children's rights here, I really think it's important to present this issue as a children's rights concern, and I know Tanya will do that eminently. Thank you.
Thanks so much, Ursula, and thanks to Fiona and Aisling for inviting me here to speak today. It's a great honour to open today's event because it's focusing on one of the most vulnerable and marginalised groups of children in Ireland, and one of the groups that's often very forgotten about. So I want to commend UCC for actually doing that. I also want to commend UCC for continuing to do this type of work. UCC is really leading in Ireland in the area of children's rights, not only through its research programme and its teaching programme, but continuing to organise events such as these, bringing lawmakers, policymakers, service providers, judges, NGOs such as ourselves together. I think what it does is it forces us to reflect together, and it forces us to challenge each other on what we need to do for children. So I want to commend you for continuing this long tradition of work. I suppose often when we look in this area of imprisonment, we rarely look at children. We often just look at people who are imprisoned themselves. We look, and more recently we're looking at the victims of crime. We don't look at what happens to people and to families when someone goes to prison. We don't look at what happens to the child that's left behind. And you know, it's such an enormous event in their life to a child. It's a crisis. It's poverty. It's family breakdown. It's stigma, and it's shame. And it's very important to remember all of that when we think of this very vulnerable group of children. There's no accurate figures in Ireland on the number of people that are affected by this, or the number of children that are affected by this. But statistics from the Irish Prison Service are kind of useful. The Irish Penal Reform Trust has shown that there's about just over 4,000 prisoners in the Irish prison system, with around 80,000 visits happening involving children. So that gives you some indication on the number of children that might be affected or have contact with prisoners or are related to prisoners in the prison service. But remember, family breakdown takes place as well, so there's lots of children who aren't being counted and who are impacted by this as well. These children might be invisible, but they're not devoid of rights, and it's really important to remember that. Ireland signed up to the UN Convention on the Rights of the Child in 1992, and that convention is very special. It's the most widely accepted human rights convention in the world, and it's very special for children because it recognises they have lots of developmental needs, it recognises they have lots of age-appropriate needs, and it also recognises that for the most part decisions are made about children that they have no chance to influence. They are dependent on other people to make decisions about them. And what the Convention does for us is it helps us to make decisions that are better for children. It gives us procedural rules and principles that help us make better decisions. I think one of the most important ones for us to remember in this area is that children have a right not to be discriminated against, particularly because of the status of their parents. It's really important to remember that. They shouldn't have a different experience of the world because of who their parents are. The Convention also requires us to make decisions in the best interest of children. So any decisions we make that concern them, we have to do so in their best interests. And this covers a whole range of different bodies, and I'll read from the Convention on this. It says, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities or legislative bodies, the best interest of the child shall be a primary consideration. That's a very broad spectrum of bodies and institutions. And in this area it would mean our courts, it would mean our probation services, it would mean the Irish Prison Service, it would mean the Child and Family Agency. All the ancillary services around children and the prison system should be impacted and affected by this. The Convention also requires us to take account of the voice or the views of children. And that's something that I think is starting to take traction and take hold in Ireland. During the referendum that we held in 2012, we did lots of different focus groups in preparation for that referendum. And what was really interesting was there's a general antipathy in Ireland around rights. And all the communications people will tell you, don't mention rights. You can mention everything else, but you can't mention rights. But what was really interesting in those focus groups was that they were with ordinary people in Dublin and outside Dublin, and they all seemed to understand the importance of listening to children and the voice of the child. They all seemed to understand it, and not as a human right, but it was the right thing or the best thing to do. So if you're trying to make a decision impacting on a child, the first thing you do is you just need to ask them. And it doesn't matter how young they are, it's something that you should try and do and try and consider. And there's no reason why we can't do this within this area. In international human rights law, the family is the fundamental unit in society. And the family is also the fundamental unit in society in Irish law as well, in the Irish Constitution. Unfortunately, there's a bit of a distinction between the Irish Constitution and international human rights law. Our Constitution only protects the family based on marriage, whereas international human rights law does protect the family. It doesn't focus on the form, it focuses on the substance or the reality of real family relationships. And we have to take a broad perspective when we think of the definition of the family in Ireland. I suppose we have to provide and ensure children's right to family life and right not to be separated from their parents where at all possible. Children have a right to grow up with their parents. That doesn't mean their mother and their father. Some of you will hear a lot in the media at the moment saying children have a right to a mother and a father. It sounds great, but it's not actually true. Children have a right to be with their parents because there are lots of different people caring for children in a parental role that don't happen to be their mother and their father. And the Convention is very clear in this area that children of prisoners have a right to maintain personal relations and regular direct contact with the parent from whom they've been separated. And they also have a right to be told about where their parents are. That's often something that's denied for children whose parents are in prison. They're often not told the truth. And it's amazing how children, very young children, as young as 3 and 4, can understand what's happening around them, and have this great ability to be able to read what's happening around them, including deception. The UN Committee on the Rights of the Child is the body that enforces the UN Convention. And it has said many things about this particular area. And one of the things it's called for is for alternatives to imprisonment for parents. And that's something we really need to get to grips with in Ireland. And that would mean, I suppose, that trying to find some other alternative instead of sending a parent to prison. And there are lots of different community-based sanctions that can be used if someone has been convicted of a crime. I suppose the first point would be looking at the role the judge has in sentencing. And there is an international trend at the moment for judges to consider the best interests of the child when passing a sentence on a parent. And the most celebrated and well-known case is actually by Judge Albie Sachs, who's here with us today. And that's M versus M. In that case, the South African court held that the mother of 3 teenage children shouldn't have been incarcerated because of her parental duties and because of the impact on the child. And the South African Constitution has a provision within it that the best interests of the child are a paramount consideration, and they have to be considered. And this decision by Judge Albie Sachs has actually inspired courts all over the world to look and consider sentencing for parents of children, and it's something he's going to speak to us today about. In terms of Ireland, unfortunately, there's no formal mechanism for the courts to consider the best interests of children when passing sentence. And certainly lawyers will plead to judges informally around this issue. But we missed the opportunity during our referendum in 2012 to include something within our constitution that would bind judges to consider the best interests of children when making these types of decisions. But we do have a new Children and Family Relationships Bill that's just being introduced. It's in the scheme stage at the moment. And what it does, which is really innovative, it introduces a new concept of the best interest of the child. And it's actually it's quite detailed, and it gives the court lots of guidance about how to determine the best interest of children. And it also introduces a new mechanism whereby the courts can listen to the voice of the child and can call on an expert to give them a view in relation to the child as well. So if we're building this architecture around the courts in relation to the family law area, there's no reason why this architecture can't be built around criminal justice cases as well. And I think we have a real opportunity to get this right and to make sure that the most vulnerable children in this country can be served appropriately by our courts in this particular area. Of course, imprisonment will happen for some parents, and we need to think about what happens then. Ursula describes some scenarios there which effectively are commonplace a lot of the time across Ireland. And one of the things that we need to consider from a children's rights perspective is the appropriateness of these types of facilities, particularly for mothers and babies, because mothers will have their babies with them in prison, and we need to think about the kind of facilities that they have to enable them to have a normal family life and create a normal early childhood for their children. But we also need to consider visitation as well. You know, sitting across from the table from your parent is not a normal family interaction for most families. Not having a chance to express any kind of physical contact with your parent, it's very damaging to do that to a child and to their parents. And there's lots of research that's been done. I know the Irish Criminal Reform Trust has done a major piece of work where they've consulted children and interviewed their parents about the impact of visitation facilities that aren't appropriate for families. And the family relationships break down. Creates a huge barrier between the children and their parents. And they stop coming to the prison. That's essentially what happens. It's too damaging for them to continue, and they lose interest in maintaining that family relationship. And so the next big challenge from a children's rights perspective is what happens then when the prisoner leaves prison and they've served their sentence. And certainly that's a huge problem as well. We have a member organisation called Ballyfermot Star, and they work with drug users in the Ballyfermot area in Dublin, and they have a huge problem with people who've been convicted of drug crimes. They leave prison and they're unable to integrate into the family. They spend about a few weeks in the family before everything breaks down and they have to leave. And it's all too easy to become homeless or to go and commit another crime. So it just perpetuates the cycle of crime, but it perpetuates the cycle of separation from the parent, from their child. And what's critical here is trying to help prisoners reintegrate with their families. They often will forget how to interact with their children, how to play with their children, how to talk with their children. It's not something that we're often born with innately. It's something that you develop as a parent over time. And you can lose those skills over time, particularly if you've been in prison for a very long period of time. And that's something that we need to think about for children of prisoners. The Child and Family Agency is responsible for the family support and family resource centres, and certainly one of the things we need to do more of is invest more in families. We need to prevent these kind of things from happening. We need to help them have a normal, and the legislation says it's kind of not very appropriate language in my view, functional families. We need to help build functional families. Well, I think if we're able to look at it from a children's rights perspective and give and respect their right to family life, I think that's the way we need to come at it in relation to these children. I think we have a great opportunity ahead of us, and I think we need to look at all the different things that might happen ahead of us. We have legislation coming down the line in this area. I mentioned the Children and Family Relationships Bill. There's no reason why we can't introduce similar legislation in this area for children of prisoners. But I think it's going to take leadership. This is not an issue that's on the doorsteps. We have a general election next year, probably. That's what the politicals are telling me. But you won't hear people on the doorsteps saying, what are you doing for children of prisoners? Nobody really cares. That's the truth of it, and that's the reality of it. And it really takes political leadership and action by people like yourselves to do the moral and to do the right thing. It also takes action by the courts. It takes action from the prison service. It takes action from the probation services. It takes action from the Child and Family Agency. And it also takes action from those of us ourselves who are advocates in this area. Ireland is going to be before the UN Committee on the Rights of the Child in January 2016. And 2016 is going to be a momentous year for us in Ireland. It's 100 years since the 1916 Rising. And during the Rising, we read a proclamation on the steps of our General Post Office, where we said we cherish all children of the nation equally. So it's a really good opportunity and chance for us to think about all the children that we haven't cherished in this nation equally. And I've no doubt that children of parents who've been incarcerated are going to be one of the key concerns for the UN Human Rights Committee. You know, what we often do for the committee is we bring issues that we can't get traction on at home to the committee. So children of asylum seekers is no doubt going to feature very highly. Traveller children in Ireland, our nomadic population, is going to feature very highly. But children of prisoners, I think, is also going to feature very highly. And we're also hoping, and I think this is going to be very important, and we need your support to do this, is try and make sure that we bring children themselves I suppose give the committee their own views in this area and bring them to Geneva to tell their own story. I think that's going to be very important as well. The message we have to, I think, hit home is that these children might be invisible, but we have to try and help them be visible. And they're not devoid of rights. They have rights. We just need to make sure everybody knows about them. It gives me great pleasure today to introduce, I suppose, one of the leading human rights defenders in the world. You always know you're with someone of great prominence when at the very beginning of the lecture someone arrives and asks for their signature on one of their leading publications. So as Judge Sachs is a rarity in this world because he's lived many different lives. He's been a freedom fighter, he's been a human rights defender, as I mentioned, he's been a lawyer, he's been a judge, and he's also been involved in developing one of the most important human rights documents in the world, which is the South African Constitution, which actually continues to inspire countries throughout the world when they're going to develop their constitution, because human rights and children's rights are centrally located within that constitution. Judge Sachs has also been responsible for a new line of jurisprudence under that constitution. I mentioned S versus V earlier on in this input, and that I suppose jurisprudence has been incredibly important internationally for other judges. It's been inspirational in many different ways. I suppose one of the things that Judge Sachs, he's no member no longer of the court, but he continues to visit different countries internationally, and you'll see in his bio that says he continues to unite divided societies. But one of the things that he also does is he continues to inspire societies that need inspiration, and I think such as ours have lost interest in protecting and defending the rights of the most vulnerable people within our country. That's something that Judge Sachs knows all about. He's someone, when he arrives, he transforms those around him. And I see that at every event that he comes to. The last event I was at where Judge Sachs spoke, people on the panel were singing throughout the day after he spoke. And that was kind of amazing because half of them were lawyers. And and they rarely do in public. So it gives me a great honour to introduce Judge Albie Sachs today, and I want to thank you for coming to Ireland and continue to inspire those of us who need inspiration.
Before I begin my presentation, can I just say a thank you to Cork. I came into exile in 1966, living in London. It would have been around about 68, 69. I'm invited to Ireland to speak to an anti-apartheid group here in Cork. And I travelled across. And immediately I felt this was different. I could call myself a freedom fighter. I couldn't in London. In London people say, well, it all depends upon how you define freedom fighter. Now if you've got to define it, you're lost. In Ireland, I could say it. It came into my presentation. It was part of the anti-apartheid struggle, not just to denounce the cruelties of racist South Africa, but to express yourself affirmatively. And then we got enormous inspiration from the Irish struggle. You just mentioned the Easter uprising in 1916, and my heart beats a little faster. And I remember reading the novels and the stories. I remember when I was working on my PhD in South Africa, going through the old Cape Law Journal, around about 1883 or something, an Irishman named Uppington had just been appointed Attorney General of the Cape Colony. And the writer commented that the only country in the world where English is spoken and the Irish don't govern is Ireland. And it just stuck in my head that Ireland had produced great leaders in the United States, in Australia, in South Africa, but was fighting for its own self-determination in its own country. So it was thank you to Cork. I don't remember anything of the visit other than that I could call myself a freedom fighter and not feel complicated about it. So moving to one of my other incarnations that's been mentioned, Judge Albie Sachs. Judges smirk a lot, and I was smirking. Not smoking, smirking, big time. It was during the court recess, and I was on what's called recess duty. And we would receive the applications of people who wanted their appeals to be heard in the Constitutional Court of South Africa, about 8 years ago. And you don't go out and you don't choose your cases. The cases come to you. And I'm smirking because this is the most hopeless application I think we've ever received. A woman had taken a credit card and gone to various supermarkets and so on. She didn't have money, she knew she didn't have money, and she fraudulently acquired a whole range of goods, not huge amounts, maybe the equivalent of 40 different cases, maybe 400 euros. She was caught. Went to court. Magistrate said, you just can't do this, it mustn't happen. I'm giving you a suspended sentence. I think it was 2 years imprisonment, suspended on condition you don't do it again. Not long afterwards, she does it again. another 30 or 40. She goes back to court. She's released on bail, and she does it again. Does it 3 times running, and not just once or twice, and not to buy bread for starving children, but all sorts of household goods, including beer and whatever it might be. Each time it's maybe a couple of €100 total involved. And now the magistrate is pretty angry. She's under a suspended sentence, and she's out on bail, and she just carries on doing that. She's been in prison for maybe 3 or 4 months awaiting trial before she's released on bail. She takes the case to the High Court on appeal, and the court knocks out one of the biggest amounts involved. She'd been sentenced to 4 years imprisonment. And the High Court judge says, okay, we'll keep the 4 years imprisonment, but we will make you available for a community service order once you have served, I think it's about 12 or 14 months. So it's increasing the chance of her getting out. But she's anguished. She says, I've got 3 young boys, teenage boys. I'm the only person they can look to. They're 2 different fathers, they're both off the scene. One's very nice, but he's totally helpless. The other could do something, but he's emotionally terrible. And I just can't go to jail again. Well, that's more or less what's conveyed in her application to our court. The Constitutional Court can't be approached except by Parliament, government agencies, the President, directly, as of right. The court has to grant leave. And in granting leave, 2 criteria have to be satisfied. First, it has to be a constitutional matter. We're not a court of appeal that deals with somebody dissatisfied with the decision. The wrong decision, they got it wrong, applied the law wrongly, got the facts wrong. That's not our function. Our function is simply to ensure that the provisions of the Constitution have been properly applied in a particular case. And we don't say that because there's a presumption of innocence in the Constitution, any case where somebody's been found guilty becomes a constitutional matter, because that would mean it's meaningless to say that it has to be a constitutional matter. Don't see a constitutional matter here at all. She's unhappy with the sentence. It's been heard by a High Court already. She went to the Supreme Court of Appeal and they refused to involve the matter, no chance of success. And that's the second criterion. So A, it has to be a constitutional matter, and B, it has to have reasonable prospects of success. I can't think of a worse case than this. She's been given every chance. The courts have softened it a little bit. Come on. It's tough on your children, but life is often very, very hard in all sorts of ways, and this is one of the consequences of the law. So I write a little memo. I wouldn't say you could see the smirk in the memo, but it was easily picked up by any of my colleagues. Recommendation, we refuse application for leave to appeal. I might say our court would receive about 100, 120 applications a year, and hear about 30 or 40 of them. So it's a very high proportion of applications will be listened to, attended to, and each one would be a landmark, establishing new principles, because we didn't have precedent we could use. We had to establish precedent with a completely new constitutional order, a totally transformed society, with a new panel of judges at the top, specially selected for their capacity to understand and breathe, if you like, the spirit and understand the language of the Constitution. And my colleague, Kato Regan, says, but Albie, have you thought about the rights of the children? I hadn't. Now that's a constitutional matter. The Constitution says in all matters concerning a child, the rights of the child shall be paramount. That becomes a constitutional matter. If the rights of the child haven't been considered in a particular case, that raises a constitutional issue. And then you have to decide, are there reasonable prospects of success? So I said, well, Kate, maybe you've got a point there, that the rights of the children hadn't been looked at. The rights of the mother, the primary caregiver, had been considered, and she was very forceful in court, saying, my children need me. I need to be there for them. But that was in relation to her rights, whether she should be sentenced to jail or not. And the magistrate and then the judge on appeal had heard the matter, and they decided, we've considered all that, forget about it. But what about the rights of the children as independent right holders under our Constitution? And one might say, even in countries where there isn't a specific express constitutional text dealing with that, the countries are signed on to the International Convention. A lot depends upon the importance and significance given to it. And I might say that our approach to these international instruments is not to look to them so much as a source of positive law, as though it's a statute introduced that you have to interpret, but as a source of values, of approach, of the way you should handle your own law, being a state that has committed itself to uphold the principles in the International Convention. So I say, okay, Kate, I'll amend my recommendation to the colleagues, but it's not going to make any difference to her. But we will establish the point that the rights of the children should have been looked at. And the only thing on the record was some little casual statement by the magistrate saying, well, the children won't be out on the street, will they? That was the closest there was to any examination about the impact of her incarceration on the rights of the children. So I said, Kate, okay, we'll establish the point that sentencing judicial officers have to pay express independent attention to the impact of a custodial sentence on a primary caregiver on the children. And we'll establish that matter principle, but it's not going to help her. In any event, we all agree then that we have to enroll the matter, and we have to underline the importance of sentencing officials looking to the impact on children of an order of imprisonment. Well, the next thing you do is you appoint curator ad litem. I don't know what term you use here, but somebody to look after the interests of the children, report independently. You get information from social workers. You expect some information from government-appointed people from their side, from the prosecution side, and some time passes and the reports come in. And I read the reports. And now it becomes a bit of a headache. Because the reports are saying the 3 boys, the fathers can't really help. There's an elderly grandmother, but who's infirm herself, she can't really help. Some years have passed now. By the time the decision's written, it was actually 7 years, with all the appeals and the backwards and forwards and so on. It's 7 years since she had last used a credit card for fraudulent purposes. And she's actually running 2 businesses. One was, I'm not sure if it was bail or maintenance, that's some court-related thing. She's using literally her inside knowledge for good purposes. And that's quite successful. And the other is a laundry. And she's the heart and soul of the maintenance project. So if she goes to jail, then not only does it collapse, but there's no source of income for the children. The bond on the house can't be paid. The children will be out on the streets in that way. The other business, there's a partner who can carry on with the other business to bring in a tiny bit of income, but it won't help the children at all. She's on the Parent Teachers Association at the school. And it's clear that she's very, very close to the kids. She's a marvelous mother in terms of the ideal parenting relationship. And it's in an area where drugs are rife and gangs are rife and young boys just get drawn into criminality and it's kind of overwhelming. And she is the person now who's keeping them together. So the recommendation, very strong recommendation from the independent persons, is that she not be sent back to prison. She's done these crazy things over and over again. And I start thinking, who's it going to help if she goes to jail? We can see the negative consequences. These 3 boys without the anchor. Going to jail, our jails are overcrowded. The only thing they do is make society feel we're doing something about criminality. We're locking people up. They don't rehabilitate, they don't serve any positive purpose. You're not doing useful work when you're there. But it does provide an important form of denunciation. So those of us who are virtuous or at any event are not caught can feel affirmed in our virtue. And it makes the world an easier place because the wicked people are caught and punished and the virtuous people now can withstand the idea that lots of nasty things are happening around them. But in terms of actually helping the person concerned, I mean, she would be stuck with other women, mostly very dysfunctional in their lives, kind of messed up, and they would gang together and she maybe learn more tricks about how to defraud people and be in that environment of total negativity. My first wife was locked up as a political prisoner and she would report. And she mentioned so strongly, I remember to me at the time, the only point of light, of elegance, of something lovely in the lives of these women was the connection with their children, with their babies inside the prison or with their children outside. More so than the men. Than I heard from other people when I was locked up and I was in isolation. The fathers, many I'm sure had very important relationships, but for mothers in particular, it was something very, very profound. So now how to respond? And it was a shock to me. I had to change my mindset. The judicial officers, until then, had said you should have thought about your children before you committed the crime. You brought it on yourself. Don't come and cry now. You're bearing the consequences of your acts. And I'm telling myself, but that's not the question. True, that might be true. The real question is, what about the rights of the children? And they are innocent. And must they sink or swim? If you sink, must they sink with you? And what kind of legal system is it that imposes a kind of destiny on children that has nothing to do with their own misconduct? but is a heavy weight that drags them down beneath the surface of the water simply because of the misconduct of their parents. And that's what led me to remember at the time in 1993, when we were drafting our interim constitution, we had quite a large meeting on the rights of the child. International people came there. I remember somebody from Northwestern University coming to speak on all their work on juvenile justice. I think that was the place that founded the whole notion of juvenile justice being treated in a different manner. Bernadine Dawn. It was so lovely to have her input and the feeling and the excitement she felt coming to South Africa that's opening up new vistas. And I was asked to speak on the rights of the child, and we felt quite emotional then. We drafted a new constitution, and why was it so important? Partly because apartheid had impacted so severely on black children. You kind of felt it even the most. I compared my childhood, and I could imagine and dream anything I wanted. If I wanted to climb a mountain, I could climb a mountain. If I wanted to go to the moon, I could imagine I'm flying to the moon. If I wanted to discover a microbe smaller than Pasteur had discovered, I could do that. So it wasn't just the beaches were there, the schools were there. Your imagination allowed you to see yourself as doing anything. And for me, the rights of the child couldn't be limited simply to the right not to be beaten up and starved. And so much of child protection law and the rights of the child appropriately is invested in protecting children from being abused. But that's just one element. And then the more progressive approach was to say, well, okay, the rights of the child also include the right to education and to nutrition and to welfare and to get on in life. But that wasn't enough. So I felt there were three clusters. The third is the right to dream, to imagine, to explore, to have curiosity, to explore your body. You're growing up as a teenager, you're concerned about your sexuality or appearance, what you're going to be, what you're going to do, to explore the world. And surely that's part of the rights of the child. And it's connected with your parents, but you're not an extension of your parents. And you have a right not only not to be abused by your parents or people around you in the streets, and not only the right to be fed, but the right to grow up as a child with imagination, with aspirations. So all of these themes are now flooding into me when it comes to imagining the children of Ms. M. And I'm going to read from the judgment. I might say I haven't read the judgment. I wrote it in, I think, 2007. So that's how many years ago? 7 years ago. And it's, I mean, if you wanted to see Mr. Narcissus, that was me last night at the table with the judgment. And I particularly enjoyed the 3 paragraphs I'm going to read to you now. That's 18, 19, and 20. I might say people who print these things out upside down, back to front, are the enemy of people who've lost an arm in a revolution. Here we are. So, paragraph 17 says the 4 great principles of the CRC, the International Convention, which has become international currency, are said to be survival, development, protection, and participation. What unites these principles and lies at the heart of our section, I believe, is the right of a child to be a child and to enjoy special care. And 18. Every child has his or her own dignity. If a child is to be constitutionally imagined as an individual with a distinctive personality and not merely as a miniature adult waiting to reach full size, he or she cannot be treated as a mere extension of his or her parents and be likely destined to sink or swim with them. The unusually comprehensive and emancipatory character of Section 28 presupposes that in our new dispensation, the sins and traumas of fathers and mothers should not be visited on their children. Individually and collectively, all children have the right to express themselves as independent social beings, to have their own laughter as well as sorrow, to play, imagine, and explore in their own way, to themselves get to understand their bodies, minds, and emotions, and above all, to learn as they grow how they should conduct themselves and make choices in the wide social and moral world of adulthood. And foundational to the enjoyment of the right to childhood is the promotion of the right, as far as possible, to live in a secure and nurturing environment free from violence, fear, want, and avoidable trauma. No constitutional injunction can, in and of itself, isolate children from the shocks and perils of harsh family and neighborhood environments. What the law can do is create conditions to protect children from abuse and maximize opportunities for them to lead productive and happy lives. Thus, even if the state cannot itself repair disrupted family life, it can create positive conditions for repair to take place and diligently seek, wherever possible, to avoid conduct of its agencies which may have the effect of placing children in peril. It follows that the section requires the law to make best efforts to avoid, where possible, any breakdown of family life or parental care that may threaten to put children at increased risk. Similarly, in situations where rupture of the family becomes inevitable, the state is obliged to minimize the consequent negative effect on children as far as it can. I like those words. Well, they captured moments of my thinking, of my life, of my imagination. And the whole court signed on to that aspect. Some of my colleagues felt her conduct had been so bad that she can't escape imprisonment. But everybody signed on to the general approach that in cases where children of primary caregivers are going to jail are being considered. If the court is alerted to the fact that the person concerned could be a primary caregiver, and you don't need a big nudge if it's a woman involved of a certain age, the court must inquire. And then if it turns out that, and we laid down certain principles in the judgment to make it practical, operational, not simply to state the broad principle, but something that magistrates dealing with these matters on a day-to-day basis, they like 1, 2, 3, 4. Or do you have to do 1, 2, 3, 4? So if there is a fair chance that the person concerned could be a primary caregiver, you're considering jail or you're sending the person to jail, then you've got to inquire into how the children will be affected. And the role of the prosecution becomes different from the ordinary position a prosecution might adopt. It's to assist the court in protecting the best interests of the children. It's not a determination of guilt or otherwise. And even when it comes to the appropriate sentencing, the prosecution also has a duty to look to the best interests of the child, and not simply the interests of the community in ensuring that there's a just sentence. And in very limited circumstances, it can make a difference as to whether or not you impose a custodial sentence. If somebody has committed a terrible crime, she can't come along and say, I murdered my husband or shot dead somebody, or whatever it might be, and say, I've got children to look after, don't send me to jail. But that's not the end of the matter. Then the court is obliged under our law now to ensure that appropriate attention will be given to the impact on the children, to call in social services, it might be, to call in members of the family, and it becomes part of the judicial function to follow through, not necessarily to make a final determination, but to ensure that the issues on the agenda and the appropriate people are concerned. And in some limited cases, it can actually make the difference as to whether or not to send someone to jail. In reasoning it out, the term paramountcy was very much discussed. It's not even primary. It's above primary. What does that mean? It can't mean that it's decisive. Otherwise, I mean, just about everything in life affects children. And if you spread it too thin, if you try to make it do everything, then it does nothing. Because then it becomes so dysfunctional and disruptive to the law that people will find excuses not to apply the paramountcy principle. They say it's just a beautiful principle, it's a guideline to us, let's move on. But you want it to be an operational, functional principle, then you have to give it an operational, functional, meaningful kind of intervention. And so we don't see it in that sense, paramountcy being, it excludes all other considerations, including protecting the public, including giving a sense of justice to the community that the appropriate decision has been undertaken. Well, that was the first part of the reasoning. And that enabled us to set aside the sentence that had been imposed on the basis that factors that should have been considered when deciding whether or not to send it to jail had not been considered, kind of barely touched upon. The prosecution argued that, counsel for the prosecution, well, they had been considered. We apply, there's a case called Zinn. You look to the nature of the crime, its severity, you look at the circumstances of the offender, and you look at the community interest, the triad. So every sentencing judicial officer in South Africa applies that triad. Whether they do it or not, they say they do it. And now what we're saying is the triad's not enough. You need would be a quadrad. You have to add the extra dimension of the impact on the children. Paramountcy then can't mean that automatically, because children are going to be negatively impacted by sending, say, the primary caregiver could be the man, the father, or an uncle, or a brother, an older brother, or more often, frequently, the mother. That in itself frees her from, immunizes her from going to jail. But in a case like this, where you've got the reports from so many different authorities, and they point so strongly in involving the community in her repair, it should have been taken into account. So we can set aside the sentence of the judicial officers, and on appeal, again, not sufficient attention had been given. Now normally, I'm sure the practice is similar here. When you set aside a decision like that because factors weren't taken into account, you remit the matter back to the sentencing body to then look into all the circumstances. But we decided that wouldn't be appropriate in this case. First of all, we had all the information that the trial court would have had. And we had even more information. We were much better informed. And secondly, years and years had passed, and it's the interests of the children required a speedy decision and less anxiety. So we decided we will now impose the sentence ourselves, and we divided. 3 of my colleagues just said she's got to go to jail. She can be made available for community service after 8 months or 12 months or something, but we've got to take account of how the community feels. The 8 of us, or 7 of us, felt no, that this is a situation in which the principles of restorative justice shout out loud for being used. First of all, she was willing to pay back the stores that she'd stolen from. And part of our order was she must go to them and look them in the eye and pay back the money. What's the objective? It's to reintegrate her into the community, into the society. It's to say the state is not going to rehabilitate her by sending her to jail in a hostile environment. The community can achieve something that the state can't achieve. That she has to do community service order. We as judges won't decide that, they are officials. But it's got to be useful work, productive work that gives her a sense of pride and dignity, and the community can recognize and acknowledge. She clearly needs counseling. This was desperate conduct on her part. She was bound to be caught. There was something compulsive. She's got to come to terms with some of her demons. So all of this is put in the order. And we took account of the fact she'd already been in jail for 3 months awaiting trial. We backdated the sentence to include that and suspended the rest of the sentence, provided she accepted all those terms and conditions. Restorative justice is interesting, emerged in the context of juvenile justice. Getting out of the ordinary court system, getting out of reliance on paying fines, being executed and going to jail, and trying to find mechanisms within society, within the community, in the family, the neighborhood, maybe the faith community, that will bring about a repair and restoration. And looking into the eyes, the offender and the offended, looking into each other's eyes is fundamental to that whole process. And this somehow seemed to be a perfect case. And sitting there just a few moments ago, it just occurred to me, I wonder what's happened to her. And I've been off the bench for some time now. I'm almost scared to inquire that maybe the kids joined gangs. Maybe she's violated in some other ways. But for me it's such a lovely story. Maybe it's safer just to keep it as a lovely story and not to test it against a reality that might be harsh. But my curiosity, I think, is stronger than my romanticism. So it just occurred to me it might be worth following up. And other cases where we judges gave decisions. In any event, what's been very thrilling to me is seeing the extent to which the case of MVS, S is just the state, and we say M to protect the identity of the children. Well, they're all grown up now. And it's been picked up all over the world. And it's been picked up because people are aching for something like that. And not to feel that you're just being a kind of soppy, sentimental person, bleeding heart, for good, solid law enforcement reasons. Making sense and being compassionate have to go together. It doesn't make sense to have a vision of the world where you're saying, tough luck. The law is not based on principles of tough luck, it's based on principles of responsibility, of interconnection between people, society. The law itself has to be accountable for the way in which it impacts on the lives of people. And if the law is impacting unjustly, unfairly, harshly, unduly harshly on children who are completely innocent, the law must take account of that. The law must have some self-reflection. It's a duty. It's a duty on the law, and all of those applying the law, to think about the impact, the knock-on effects of what's being done. And sure, you can say she should have thought about it before she committed the crimes. But you say to the judge as well, you should have thought about it before you sent it to jail without inquiring what would happen to the children. So in that sense, the interconnectedness of law comes in. And maybe we feel more strongly in South Africa about this because we have a principle called Ubuntu. Anne Skelton. Anybody in this room know Anne Skelton? Just put up your hands. Of Anne Skelton. Put up your hands so you can see. Okay, a fair number. She's the director of the Centre for Child Law at University of Pretoria. And her doctorate, which I was one of the supervisors of, is on restorative justice, Ubuntu, and child law. And Ubuntu is a very profound philosophical concept in African society that underlines the interconnectedness of all human beings. I am a person because you're a person. I can't separate my humanity from acknowledging your humanity. And acknowledging your humanity doesn't undermine me, it doesn't restrict my freedom and autonomy, it enriches me as we enrich each other through that sense of interconnectedness. And somehow that's that spirit of Ubuntu that is now infusing the best aspects of our law. And just this very last week, as though they did it because they knew I'm coming to Cork to speak on the rights of children, affecting whether or not to send somebody to jail. And Ms. Peters in Cape Town, who was the main organizer of a social movement called the Social Justice Committee in Cape Town, a community leader, very popular. But she and her husband, according to the evidence, lost it and killed a guy who'd stolen a radio from them. And at first the argument was the police are stitching her up because she's a pain in the butt. She's always complaining and announcing and exposing and so on. But the evidence was compelling. And now the judge has said, they've got children. If both parents go to jail, who's going to look after the children? And how can we send the one parent to jail and not the other parent when they're equally responsible? So now we have to follow the principle of taking account of the interests of the children, and the family of the deceased are agreeable to that approach because they're all living in the same community. And they know this was a bizarre, terrible episode. It's not going to bring their son back to life. And they would prefer to have a meeting between the families and some kind of community service order and ensuring that the children are properly looked after than to send the parents to jail. Perfect for this conference, and I think a good note on which to end my presentation. Thank you.
Thank you so much for that, Judge Sachs. Inspirational, like I said, and fascinating as well. You have this amazing ability to bring the law to life and to inspire us about the importance of law and how law can give you the answer for a lot of these really critical social problems that we have in our society. I'm going to open the floor for a few minutes for a few questions, if that's okay.
Sure.
Any questions? Could you introduce yourself as well?
Yes, I'm Sharon Linton from the University of Oxford Centre for Criminology and talking to judges about sentencing. And I've looked at this case a lot, and something I hadn't realised until you said about it today is that the mother, that there had been so long between the offences and you looking at the case, and also that she was such a good mother. And I wonder, would it have been a case that attracted your constitutional attention if she had not been a good mother?
When we gave leave to appeal, we didn't know she'd been a good mother. And I made this concession to Kate, but not just because she's Kate, my friend, and she's fantastic, and I love her mind and so on. But she was right that if you state in the Constitution, in all matters concerning a child, the interests of the child shall be paramount. You can narrow it down to say custody, adoption, concerning a child, or you can look at it in the context of why we got a constitution, the fight against apartheid, the fight for emancipation. You've got to give it a wider thing. And we hadn't considered it, and I hadn't considered it. So it's easy to be cross with the magistrate and the High Court, but the great Albie Sachs, what did you call me? The world's leading freedom fighter, hadn't considered independently the interests of the child. And that's why the judgment speaks about the need for a change in mindset. The law is there, the law's always been there, we've always used the phrase as a kind of mantra, an incantation, but we've never considered it in terms of what does it mean when you're passing a sentence to take account of the interests of the children. So I was prepared to hear the matter, and we would have heard the matter on that basis, but the assumption was it wasn't going to benefit her. And only when the reports came in, it became clear that to insist that she goes to jail now, it would be so violatory of any commonsensical approach to law. I don't want to be too negative about my three colleagues who went differently. I could understand that because they captured the emotion I had when I first read the papers. But this was also an opportunity to bring in the principles of restorative justice, to make them part and parcel of our jurisprudence. So that was the way it went. I think if we'd had the feeling, well, she's a crook, she can't control her own life, she's setting a terrible example to the kids in terms of conduct and behavior, she can't manage the children at all, I don't know. One always hesitates to bring in social services to provide alternative, but one might have felt, well, fostering or getting somebody else involved might have been the best result. But when these very strong reports came in, so affirmative, and there was something admirable about her. She didn't give up the fight. Well, there are lots of crooks don't give up the fight, and they fight protesting their innocence, all the way through. But she was adamant all the way through. She fought and fought and fought, came up to us. But then she set up these two businesses. She was managing things. There was a sense that here is a strong human being, not a failed, collapsed human being who needs tender nurturing, but a strong human being who could become a leader in the community. And surely the role of the courts would be to try and strengthen her relationship with the kids, to give them a real chance.
I'm Ben Rates from Huddersfield University. I'm interested in the media reaction when these principles are put into place, because in the UK, where I'm from, the media's baying for revenge, and so often people can be given quite hefty community sentences, but the media says they got off, a suspended sentence, they got off. And I'm just wondering whether there's been negative press about this.
No, there wasn't. It didn't make big waves, positive or negative, but there wasn't a great hostile reaction. A lot of the writing is attentive to those emotions, and it's making it very, very clear. People can't use their children to hide, to get away from what should be just response from society. But she's not using children. We are concerned about the children. It's not her dilemma that's at the centerpiece. And then I quote quite extensively from other judges who say community service is not a piece of cake. The one judge actually says the easiest life you can imagine is being in the army, he said, in a monastic order or in jail. You simply obey orders. When you're doing community service, you have to think, you have to do things. It's not pain-free. So he spelt it out, and I quoted him to make that point, so that any journalist reading it could get that point. And maybe we don't start with, well, let me put it another way. I've often said we should always be skeptical about law's pretensions, but never cynical about law's possibilities. And sometimes the skepticism of the journalist it morphs into cynicism. And so anything that's done that has a virtuous, hopeful side to it is immediately undermined and attacked, and that given kind of cyanide. But you want to preempt that, so you want to acknowledge the skepticism, which is good and society needs it, and at the same time find a way of saying, but nevertheless. So when you read, if you can do the backwards, forwards, upside down journey, or maybe pick it up from the law reports, you'll see that it was necessary to address the journalists and people, not only journalists, lots of decent people in society, confused and worried and so on, to give them a sense of reassurance that we haven't lost our marbles and we're not falling over backwards to be nice to people who've been horrible to society. That is in the judgment, and it's not just a technical answer, and it's not just a question of interpreting what the CRC says and what our Constitution says. That becomes part of the mode of addressing the broad community.
Time for one more question.
Hi, Linda Moore from Ulster University. I found the presentation, like you did, really so interesting and inspiring. I'm wondering whether we should be looking towards individual discretion of judges to take children's best interest to account, or looking towards legislation which would more across the board kind of eradicate the imprisonment of parents particularly for less serious charges. I was kind of thinking of an example came to mind when you were talking of a single mother in Northern Ireland who was sent to prison for stealing a £10 pair of jeans, and the local media went crazy about it, saying this woman shouldn't be sent to prison. She's got a toddler with no one to look after them, and she was released then. But kind of in balance, wondering, should we focus our energy on ensuring that children's rights are upheld at the judicial level, or trying to get laws that prevent people going to prison?
I would say both. And the advantage of legislation is not only it lays down rules and attends to all the different issues and brings in the different institutions, it gets people talking and considering the issue. So I wouldn't like to see this as the judicial function is in a way limited to seeing the matters on the agenda, that it's acknowledged and recognized. The state is now sending a caregiver to jail. The state is doing something that can be extremely destructive to the children. The state has a duty to take account of and find an appropriate response to the impact on the children. And that's maybe as far as the judicial involvement can go. In some cases, maybe they can go further, it can be very specific, but that's the minimum. And then I think you would want all the different agencies involved to make their contributions and want to have society having a less angry, if you like, approach to human beings, and a more thoughtful, constructive way of repairing damage.
It's a quick question.
Very quick one,
Yeah.
Paul. My name is Paul Murphy. I work in the Irish Prison Service. And it kind of follows on from your previous answer. It was a fascinating talk, and thank you for that. I'm just wondering how resources to meet the needs of children followed the changes in the law. So if a parent, for example, ended up going to prison despite having considered the needs of the children, has South African society put in place adequate resources to meet the needs of those children?
There's a shortage of resources generally. I mean, the whole question of children in law, we had one case that dealt with child witnesses, particularly children who've been subjected to abuse, sexual assault, or whatever it might be. And we have quite extensive legislation. Some of it's been struck down as being insufficiently protective of the rights of children. I discovered for the first time the role of the intermediary. The child doesn't testify directly. The child works with an intermediary, a trained person attached to the courts. And that takes away so much of the strain of this totally artificial environment of the, even if the child doesn't have to confront the abuser face to face, which can be terrifying, that's relatively easy. You can have television and separate rooms. The child doesn't understand the procedures, and who's the strange person asking me questions with this funny voice? So you have trained intermediaries now who will, as it were, act almost like a translator, take the legal question and convert it into a question the child can comprehend and get an answer from the child that's appropriate. That becomes part of the record. But we discovered we've got people who want to be intermediaries, and that's something, particularly in African society, they're marvelous storytellers, they're people with a fantastic capacity to mediate and to understand and interpret. It's partly interpreting into an African language, but it's also interpreting into the child's worldview, and the money isn't there, not nearly enough. And it goes all the way through. So there are shortages of funds. The social disrepair in our country is immense. The number of now, because of HIV/AIDS, we had literally tens and tens of thousands of child-headed families where both parents had died. So the drama is very profound, but you can't do anything unless you have a clear understanding of what the issues are. And you draw on the resources, and community resources can be so powerful. So the state has a critical role to play, but it can function so much more effectively if it's involved with the community and gets the backup of the community. But you're absolutely right, to have great ideas and there aren't resources to back them up can be very, very disheartening.
Okay, I'll bring to a close there. I just want to thank you, Judge Sachs, for that amazing input. I know you said judges are the storytellers of the 21st century, but I think some judges are poets as well, and I think certainly there's a reason why that judgment has travelled, and it's because it contains poetry as well. I got a lot from it, and one of the things I got from is we need law, actually. You can't make a decision in the best interest of children if you don't have the legal basis to do it, and that's something I think that we need in Ireland. In this area. The other thing I got is you also need the supports as a judge as well to be able to make that decision. You need an expert, you need ancillary people around you to be able to make those decisions. And often in Ireland you meet members of the bench, particularly the district courts and the circuit court, and they'll say we just don't have the resources we need, and we're making very difficult decisions that impact on children. But I think what's very critical for us is that you've shown us that the sky hasn't fallen in just because this type of decision has been made, and it's been really important for the courts in South Africa to be able to use the law that you framed in the framework. And the critical area of all of that is to remember the child, is to try and centre these decisions around the best interests of children. That's the critical thing that we need to do. We need to change our mindsets. We need to rethink this whole area, and I think you've very eloquently empowered us to do that. So thank you very much.
Thank you.